welcome to the 276th edition of Legal Empowerment Through Interaction lecture series. This, in fact, is the second part of the lecture titled Judge-Made Law in Criminal Trials. And today's topic is distinction between investigations under Chapter 12 and 15 CrPC. Dealing with the subject is Justice V Ramkumar sir, and we are privileged with the presence of Justice Nagamuthu sir and all of you wonderful participants. Without wasting any time, let us go directly to Ramkumar sir. Sir, over to you.
Thank you, Shyam. Good evening, friends. Distinction between the two types of investigations, one under Chapter 12 CrPC, police investigation, then under Chapter 15. There also the section says investigation by a police officer or any other person. Now, we will first deal with section 156.3. Subsection 3 of section 156 CrPC reads, any magistrate empowered under section 190 may order such an investigation as above mentioned. As above mentioned means as mentioned in section 156.1. So he should have the jurisdiction to conduct an investigation. It should be a cognizable offense revealed by the information or suo motu noted. Then he has the power to conduct investigation. Now, any magistrate empowered under section 190 may order such an investigation as above mentioned. Investigation by a police officer of the appropriate authority under section 156.1. As you all know, under section 156, the jurisdiction of the court magistrate as well as the police station is virtually co-terminus, co-extensive. You decide the territorial limits of the magistrate and territorial limits of the police station by applying the same yardstick under section 156.1 CrPC. Now, there was a view that the power under section 156.3 CrPC can be exercised only at the pre-cognizance stage, and it cannot be exercised after the court has taken cognizance of the offense. I have got nearly 12 rulings, including 2 3-judge bench rulings. The 3-judge bench ruling is Devarapalli Lakshmi Narayana Reddy versus Narayana Reddy, AIR 1976 Supreme Court 1672, and then Ramdev Foods Products Private Limited versus State of Gujarat, AIR 1915 Supreme Court 1740. But in the year 2019, another 3-judge bench of the Supreme Court in Vinubai Haribai Malaviya versus State of Gujarat, 2019, 14 scale, page 1. The judges are Rohinton F. Nariman, the author of the judgment, Suryakant and Justice Ramasubramanian. They have taken the view that the power under section 156.3 CrPC can be exercised even after taking cognizance of the offense, but not after the commencement of trial. Even though I am personally in support of this view, in fact, I have welcomed this view through 2 of my articles. The said decision has violated the principles of stare decisis in ignoring 2 binding 3-judge bench decisions of the Supreme Court. We will not make a further discussion on that ruling, but I welcome that ruling. Now, order for investigation can be made to whom? The Kerala High Court in State of Kerala versus Musa Haji, 1993 2 KLT 609, corresponding to 1994 Criminal Law Journal 1288, speaking through Justice K.T. Thomas, had taken the view that a magistrate cannot order under section 156.3 CrPC any police officer other than the officer in charge of the police station to conduct investigation, and that the state government alone can order such investigation. Besides the station house officer, the state government alone can order such investigation. The said decision was affirmed by the Supreme Court on 8/4/1997. I think it is not reported. In Criminal Appeal 410 of 1994 by the Supreme Court. Subsequently, the Supreme Court again, speaking through the very same Justice K.T. Thomas, in CBI versus State of Rajasthan, AR 2001 Supreme Court 668, Justice K.T. Thomas is the author of the judgment. Along with him was Justice R.P. Sethi. took the view that the magistrate cannot, under section 156(3) CrPC, order investigation by the CBI. Magistrate cannot straightaway order investigation by the CBI, and that the Constitutional Court alone can make such orders. Musa Haji, referred to above, had been upheld by the Supreme Court, which was upheld by the Supreme Court by a two-judge bench, was again approved by this this decision, CBI Justice Thomas Rulli. In para 16 of Hemant Dashmana versus CBI, AIR 2001 Supreme Court 2721, again speaking through Supreme Court, again speaking through Justice K.T. Thomas, observed in para 16 that even though the power of the criminal court to order further investigation is under section 156(3) CrPC, the court can, the court's power is only under 156(3). 173(8) is not the court's power, it is the power of the police. But the Supreme Court observed that the court can trigger into motion the power of the police to conduct further investigation under section 173(8) CrPC. This is how the courts are also exercising 173(8) power, further investigation power, though it is technically the power of the court. Anyway, after Vinubai, it is a great relief that even the court can exercise 156(3) even after cognizance, after the commencement of trial. So court need not go to 173(8) for ordering further investigation. In para 25 of Mariam Rashida versus State of Kerala, AR 1998 Supreme Court 2001, a two-judge bench of the Supreme Court speaking through M.K. Mukherjee, now it was held that further investigation being continuation of the old investigation, it can be conducted only by the same agency. I have my own personal reservations about this view. Of course, subsequently also Supreme Court affirmed this view. Just because further investigation is a continuation of the investigation already made, why should it be confined to the same agency? It is only further investigation. Further investigation can be conducted by any agency. Why confine it to the same agency? I have my own reservations, of course. One day Supreme Court may say or may not say. What is wrong in another agency continuing the investigation from the stage at which the earlier investigation had stopped? Does it bring about the same? Does it not bring about the same result? So, and what about when the Constitutional Court's order the investigation to be taken over by the CBI? The state police may be conducting a particular investigation on the motion of somebody. The Supreme Court or the Constitutional Court's order the investigation to be taken over by the CBI. What is the CBI doing? CBI is taking over the investigation and continuing the investigation only from that stage. I don't find any justification for that view. Anyway, it was a very sensational case, that ISRO espionage case, in which Mr. Nambi Narayan, this great scientist, was humiliated like anything, and even now he has not received the complete recompense. In Disha versus State of Gujarat, AR 2011 Supreme Court 3168, Justice Sadashivam and Dr. B.S. Chauhan authoring the judgment, the held that magistrate can, under section 173(8) CrPC, direct the CBI to investigate a case after the charge sheet has been filed. This runs counter to the earlier decision. Here, the great judges, Justice Chauhan and Justice Sadashivam, held that magistrate can order under section 173(8) CrPC the CBI to further investigate the case. If the magistrate can, if the power of the court under 156(3) after the cognizance is taken can be exercised by making use of the power of the police under 173(8). Here is a decision which says that under 173(8) the magistrate can direct investigation by the CBI. Anyway, there is these. I am only placing before you all these decisions, and let us try to acquit ourselves from this conundrum. Now, the consequence of an order for investigation under section 156(3) CrPC. Once a complaint is forwarded to the SHO concerned for an investigation under section 156(3) CrPC, even in the absence of a direction to register an FIR, the police are bound to register a case treating the complaint as the FIR. and are also bound to investigate the case, because case is sent for investigation. When once a case is sent for investigation, it presupposes the registration of a crime, and the complaint itself gets transformed into an FIR. That is what the Supreme Court said in Madhubala. Madhubala versus Suresh Kumar. Here, 1997 Supreme Court, 3104. Supreme Court speaking through Justice M.K. Mukherjee. Thus, a direction under Section 156(3) CRPC will definitely result in a police report, unlike an investigation under Section 202, Clause 1 CRPC. Then we come to Section 202(1) CRPC. Subsection 1 of Section 202 CRPC, I will read it for your benefit. Postponement of issue of process. Any magistrate on receipt of a complaint of an offence of which he is authorized to take cognizance or which has been made over to him under Section 192 may, if he thinks fit, and shall, in a case where accused is residing at a place beyond the area in which he exercises his jurisdiction, postpone the issue of process against the accused and either inquire into the case himself or direct an investigation to be made by a police officer or by such other person as he thinks fit for the purpose of deciding whether or not there is sufficient ground for proceeding. Now, it may be relevant to read subsection 1 of Section 162 CRPC also here. Statements to police not to be signed. Use of statements in evidence. No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it, nor shall any such statement or any record thereof, whether in a police diary or otherwise, or any part of the statement or record, be used for any purpose save as hereinafter provided at any inquiry or trial in respect of any offence under investigation at the time when such statement was made. The bar against taking the signature of the persons interrogated and the user of their statements only for eliciting a contradiction, if called as a prosecution witness under Section 162(1) CRPC and is proviso, applies only to investigation under Chapter 12 CRPC, as is specifically stated in Section 162(1) CRPC itself. The said bar does not apply to an investigation under Section 202(1) CRPC, which is in Chapter 15 CRPC, and that too for a different purpose. I quote my own ruling in Biju Purushottam versus State of Kerala, 2008 3 KLT 85, corresponding to 2008 Criminal Law Journal 4488. Now, you must have noticed the distinction. 162 says no statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it, nor shall any person be, etc. Then under the proviso, that statement, if whatever statement is proved, can be made use of only for eliciting a contradiction under Section 145 of the Evidence Act, not a corroboration under Section 157 of the Evidence Act. Now, the question is whether this bar will apply to an investigation conducted by a police officer pursuant to an order under Section 202, Clause 1 of CRPC. Therefore, if the magistrate has directed an investigation by a police officer under Section 202(1) CRPC, the police officer is free to take signed statements because it is in Chapter 15. So 162 clearly says no. See, I will read it again because no statement made by any person to a police officer in the course of an investigation under this chapter. Investigation under this chapter means Chapter 12. Now, investigation order under Section 202(1) CRPC is not an investigation under Chapter 12. It is an investigation under Chapter 15. Therefore, the bar under Section 162 has no application whatsoever. Therefore, if a police officer is directed to conduct an investigation under Section 202, Clause 1, the police officer can record signed statements. He can take statements and get the signature, even thumb impression, etc. And during the trial of that case, that statement can be used like any other previous statement. It can be used not only for contradiction, but also for corroboration. That's the distinction. Whereas If it is a statement recorded by a police officer during the course of investigation under Chapter 12, it cannot be used for proving a corroboration. The only purpose is for eliciting a contradiction. That too, in the case of a witness called by the prosecution, not by the defense or not a court witness or any other witness. The investigation, which is part of inquiry under Section 202(1) CrPC, is to ascertain what is the purpose of this investigation under Section 202(1). 202(1), the purpose is to assist the magistrate, to facilitate the magistrate to decide whether he should proceed further and issue process, or whether he should terminate the proceeding by dismissing the complaint under Section 203. This is the purpose of that investigation. The investigation, which is then the distinction between these two types of investigation under Section 204 for issue process or whether to dismiss the complaint. These are the purposes for which the investigation is conducted. That investigation under Section 202(1) CrPC will not result in a 173(2) report. Will not result in a police report filed under Section 173(2). It will only result in a report on the basis of which the magistrate can decide whether he should proceed further and issue process, or whether he should prematurely terminate the case by dismissal under Section 203 CrPC. This distinction was made out in a 3-judge bench decision of the Supreme Court in Mohinder Singh versus Gulwant Singh, AR 1992, Supreme Court 1894. 3 judges: Ratnavel Pandian, M. Fatima Bibi, Yogeshwar Dayal.
Please repeat the citation, sir.
Mohinder Singh versus Gulwant Singh, AIR 1992, Supreme Court 1894. The judges are Ratnavel Pandian, M. Fatima Bibi, Yogeshwar Dayal. Then there are ever so many decisions of the Supreme Court making out this distinction between the investigation under 153 and 202(1). Those of you who are interested in knowing the citations, I will give the citation. AIR 2004, Supreme Court 1492. Shashi Jaina versus Kadal Swain, AIR 2004, Supreme Court 1492. B.N. Agarwal, Justice B.N. Agarwal. Then Chief Enforcement Officer versus Videocon International, AIR 2008, Supreme Court 1213, 1213. Thakur, Justice C.K. Thakur. Then again, Dilawar Singh versus State of Delhi, AIR 2007, Supreme Court 3234, Justice Arjit Pasai. Then again, National Bank of Oman versus Barakara Abdul Aziz. It may be Vadagara. Barakara Abdul Aziz. 2013, Volume 2 SEC 488. Justice K.S. Radhakrishnan and Deepak Misra. Then Fiona Shrikanda versus State of Maharashtra. 2013, Volume 14 SEC 44. K.S. Radhakrishnan. 2013, Volume 14 SEC, page 44. K.S. Radhakrishnan, Justice. Then Vijay Dhanuka versus Najima Mamtaz. Vijay Dhanuka versus Najima Mamtaz. 2014, 14 SEC, Volume 14 SEC 638 by Justice C.K. Prasad. Thus, such a direction for investigation will not lead to the registration of an FIR or will not culminate in the filing of a final report. The investigation which a magistrate can direct under Section 202(1) CrPC need not necessarily be an investigation by a police officer. The Section 202 itself uses police officer or such other person whom the magistrate may deem fit. Therefore, the magistrate can direct any private person also to conduct an investigation by such person as he thinks fit. The Kerala High Court in Madhavan Nambiar versus Bhaskaran, 1995, 1 KLT 591, speaking through Justice Balanarayana Marar, upheld the order passed by the magistrate appointing an advocate to investigate the case so as to enable the magistrate to decide whether he should issue process to the accused or not. That was a civil case, a parallel civil case also pending. Therefore, the learned judge found it convenient to appoint an advocate as an officer to conduct an investigation under 2021 CrPC to assist the magistrate to decide whether he should issue process or not. Subsection 3 of section 202 makes it very clear that if the investigation under subsection 1 is made by a person not being a police officer, such person shall have all the powers conferred by the CrPC on an officer in charge of a police station except the power to arrest without a warrant. Now, recently, I have not read that decision. Recently, I am told that Supreme Court has taken the view that even in the case of an investigation by a police officer, he does not have the power to arrest in view of the subsection 3 of section 2. The section clearly says not being a police officer. And I don't know, supposing an arrest of the accused is found necessary for eliciting, effecting a recovery under section, recovery falling under section 27. How I don't know how the police officer may be helpless.
So this was considered in Ramdev Food Products, pre-judge bench.
I see, Ramlal Food Products also.
It is clear that no powers to arrest even by the police.
Police officer.
Justice
But why did they do? Why did they say so? Suppose because this is a case where there was no investigation by the police under 153 or under chapter 22. So, supposing the matter has to be elicited only through a recovery falling under section 27. Now, of course, there is the observation by the Supreme Court that even when an accused is on bail, he can be requested to appear for a recovery without arresting him. I don't know how far it is practical.
Because there were two questions out of which the second question which fell for consideration was this particular thing, whether the police is having a power to arrest in course of an investigation under section 202.
Then why did they exclude other than a police officer?
But sir, the thing was that investigation under section 202 is when the magistrate is in season of the matter, yes, after having taken cognizance. And it is only for the purpose to decide whether there is any sufficient ground for proceeding further or not.
Further, yes.
Because only because of that, the Supreme Court said, because it is at such a premature stage, you cannot exercise the power to arrest by the police, because that would be contradicting the very terms of the section. That was the reason by the three-judge bench.
The court indulging in judicial legislation. How can you forget that those words in the section, in the subsection, other than a police officer, specifically excluded? Yes. Now, lastly, in which all cases the magistrate is debarred from directing an investigation under section 202(1) CRP. There are three classes of cases where the magistrate cannot order an investigation under 202(1). One where the offence complained of is triable exclusively by a court of session, in view of the clause A of the proviso to section 202(1) CRP. If the offence is exclusively triable by a court of session, the magistrate is debarred from directing investigation under 202(1) CRP. The purpose is very clear, because this is a private complaint. Therefore, alleging commission of sessions offence exclusively triable by court of session. Unlike in a police charge case, there will not be any material for the accused, for the defense, to confront the witness with his previous statement. There is no previous statement. 161 statements are not there. Therefore, in fact, there is a beautiful decision of the Kerala High Court. I don't know the citation. It is 87 KLT, full bench decision. Speaking through Justice Padman, probably Premraj may be able to help us. 1987 2 KLT page, I don't remember, where Justice Padman, speaking for the full bench, said that purpose of this mandatory inquiry in the case of an offence exclusively triable by a court of session is not to place the accused in a disadvantageous position. He will be in a disadvantageous position without a previous statement of the witnesses. Therefore, it is to obviate that difficulty that the legislature has made it mandatory inquiry. Do you remember? Pardon?
That was upheld in Rosie by Justice Thomas.
Supreme Court.
Subsequently, Rosie was state of Kerala.
Yes. That's a full bench decision, 87 KLT, 2 KLT, or I don't remember the page number. Then second category is where the complaint has been made by a court. First part of clause B of proviso to section 202(1) CrPC excludes the court. If the complaint is by a court, then for ordering investigation, the magistrate is debarred from ordering investigation. Third is where the complainant and the witnesses have not been examined under section 200 CrPC, then without examining them, the matter cannot be ordered, investigation cannot be ordered. In fact, that includes a public servant also, because under the proviso, first proviso to section 200, if the complaint is by a public servant or court, then both are exempted from giving sworn statement. Even without a sworn statement, magistrate can take cognizance. But there, the section says the complaint is in writing. Supposing the complaint is an oral complaint, can the magistrate exempt the public servant or even the court from recording this examination on oath, recording the sworn? After all, a complaint by court will not be by the court itself, by the presiding officer itself, except a case falling under section 190, clause 1, clause C of section 191, where the court has straightaway taken cognizance of an offence which was committed in the presence of the magistrate. Where an offence is committed right in the presence of the magistrate, magistrate himself is taking cognizance. Barring that, for example, 195(1)(b), offences falling under section 195(1)(b), all those cases, court, even though complaint can be, the magistrate can take cognizance only on a complaint by the court. Their section itself says that complaint, the court can authorize a person to file the complaint on behalf of the court. Therefore, it is that authorized person who is figuring as the person who preferred the complaint. Directly, court doesn't appear, except in a case falling under section 190, clause 1, 190 subsection 1, clause C, where the offense, court magistrate has taken cognizance directly in regard to an offense committed in his very presence. These are all my takes on these two sections. Now, supposing it is an oral complaint by the court, should he not be examined? The court is exempted from examination under section 200 only in the case of a complaint in writing. Likewise, a public servant who has preferred a complaint for an offence committed against him in the lawful discharge of his duties as public servant, if the complaint is in writing, he is given the exemption under the first proviso to section 200. But supposing it is an oral complaint, is he exempted? Even while ordering investigation under section 202(1) CrPC, even if it is a written complaint by a public servant, he has to be examined before the court magistrate ordering investigation under section 202(1) CrPC. But if he's so whether it is oral or written, public servant does not enjoy the exemption from examination if the magistrate wants to order investigation under section 202(1) CrPC. But court, there's a total exemption, it seems, because clause 202(1) says, I'll read, where the complaint has not been made by a court unless the complainant and the witnesses present, if any, have been examined on oath. That is clause B of the proviso to section 202(1) CrPC. So the court is given a total exemption. So according to me, even if it is an oral complaint by court need not be examined, even though section 202 says only complaint in writing. I am sorry, section 200. Section 200 only says complaint in writing. But even if it is an oral complaint by the court, the court need not be examined, even if the magistrate is ordering investigation under section 202(1) CrPC. But if it is any other person, including a public servant, who is exempted under section 200, that person will have to be, his sworn statement will have to be recorded under 200 itself, if the magistrate wants to order investigation under section 202(1), clause 1 CRPC, in view of clause B of the proviso to section 202(1). This is my overview on these two sections. My sound is getting cracked. It's a cracking of my sound because of a respiratory problem. Sorry.
Because Diwali is fast approaching. That's the reason.
Not the reason.
Thank you, Ramkumar sir, for drawing that fine distinction. Nagamuthu sir, can we have your comments on?
Yes. So I fully agree with my brother Justice Ramkumar. I want to highlight few more aspects of the matter.
Yes.
As we rightly pointed out, this is the law of the land today, as declared by the Honorable Supreme Court, that the inquiry under section 202(1) is different. I'm sorry, investigation under 202(1) is different from any investigation being conducted under chapter 12 of the code. Very good. Now, if you look at chapter 12 of the code, it speaks on the power of the police officer to investigate a cognizable offense. That is section 156. So the source of power of a police officer to do investigation in respect of a cognizable offense flows from this chapter 12, more particularly from section 156 of the code. When he acquires such power to investigate because he finds that it is a cognizable offense which is made out, then what is the procedure to be followed is also dealt with in section 157. Then what is more important is section 160, which says that any police officer making an investigation under this chapter may summon any person. So the power to investigate flows from this chapter. Procedure to be followed is regulated by this chapter. Then section 160 clearly gives power to him to summon any person during such investigation under this chapter to appear before him to make a statement. Now, as my friend pointed out, section 161 again covers any investigation under this chapter alone. So therefore, a statement of a witness can be recorded under chapter 12 by a police officer investigating a case. No quarrel over that. Now, similarly, if a statement is recorded under section 161, it goes to the bar contained in section 162 of CrPC. Therefore, putting together, unless the investigation is under this chapter, neither 161 nor 162 of the code is applicable. So far as confession is concerned under section 164, in the course of an investigation under this chapter again, confession can be recorded by a magistrate. But there is one small exception in that, which says, or at any time afterwards, before the commencement of inquiry or trial. So before commencement of the inquiry or trial, confession can be recorded. So this is, so therefore at any stage, whether it was a private complaint case or police case, anything for that matter, there can be a confession recorded before the commencement of trial. So after the commencement of trial, there is no scope to record any confession. I think so. Now with this background, let us now come to section 202. 202 in simple terms says that the magistrate, if he thinks fit, order investigation, direct an investigation. So therefore, the power for a magistrate to do investigation flows from this section very particularly, that too only on an order being passed by a magistrate. Without the order, he cannot do. Now, source of power, there is no doubt. After the order is passed by the magistrate, what is the procedure to be followed by him? If we are to follow the judgment of the Honorable Supreme Court saying that chapter 12 is not at all applicable, then the police officer who is doing investigation at 202 cannot summon any person as a witness at all. Point number one. Point number 2, he lacks jurisdiction even to record a statement from a witness. He cannot record any statement at all. Number 2. Number 3, a witness is not bound to make a true statement as mandated in chapter 12. He can very well say that I won't make any statement, go ahead with your investigation. I won't make any statement. So these are all the consequences. With this background, let us go to the definition of the term investigation. As per section 2H of the code, investigation means other than an inquiry, collection of evidence. That's what I feel. Yes. Investigation includes all proceedings under this code for the collection of evidence conducted by a police officer. Right? So he can collect evidence. 161 is not an evidence at all. That's the reason why in chapter 12 a specific provision has been made to summon somebody, to examine somebody, to record the statement of somebody, making it mandatory for the person summoned to make a true statement. All these things are there procedural. If collection of evidence would include the summoning, recording, making statement, everything, then there need not be any separate provision in chapter 12 empowering the police officer to do all these things. Now, as we have already seen, chapter 12 is not applicable to 202 at all. If that is the case, it is very limited. Collection of evidence means how to make the collection of evidence. What do we mean by that? Collection of evidence means some recovering some documents, recovering some material objects, or finding the names of some person who was seen the occurrence. That is all. Anything more than that could be, whether it could be done. If strictly we go by this interpretation given by the Honorable Supreme Court, where is the power to make statement of 161, to record a statement of 161? Then what is the purpose of investigation? What could be done by a police officer? Now, let us take one given situation. There is a private complaint made to the magistrate about theft. The thieves are not known, right? Now, court is bound to take cognizance under 190 because court has seen that there is an offence which is cognizable committed. Cognizance is taken, though the culprits are not known. Thereafter, the magistrate cannot straight away dismiss the complaint under 203 because names of the assailants are not known. He has to order for further for investigation, not further investigation. I'm sorry, for investigation of 202(1). During the course of such investigation of 202, if the accused are brought to light, then it will be reported to the magistrate. This is not a report as normally done under chapter 12 and 173(2). This is only a formal report, collection of evidence, placing the same before the magistrate. Based on that, the magistrate, instead of dismissing the complaint, issues summons to those persons who have been found out by the police. This is the purpose. Now, in this case, in this situation, if statements of witnesses cannot be recorded, how can the names of these real culprits be brought on record by way of evidence? See, the one way to collect the CCTV footage and all that, that is collection of evidence, all right. But there are no such thing. Fingerprint is not available. There is no other evidence which could be collected except the oral statement of witnesses. When you prevent the police officer from recording oral statement from the witnesses, then he cannot even summon. How can he report to the magistrate that these are all the persons who committed the crime? This problem is there.
It is here that we find the relevance of Vinubai.
Yes. So let me also make some comment about, I am only placing this before this August audience for further debate. Mr. Prem is very anxiously waiting to express his views on that. Now, sir, just Ramakrishnan sir has also joined now, fortunately. Now let us come to Vinubai. Vinubai has got nothing to do with chapter 12. That is a regular investigation. It speaks only of further investigation, right? This has got nothing to do with the 202. Benubai cannot have anything to do with the 202 inquiry investigation at all. Now, Benubai says that a magistrate has got power to order for further investigation. The only welcome aspect from out of the case is that such a request can be made not only by the police officer investigating, now by the victim family, or by the accused himself can ask for. That is really a very welcome trend. That's a good development of law made. Now, to that extent, we have got no difficulty. Now, having said that, now the judgment restricts such power of the magistrate to order for further investigation until charges are framed, that is, trial commences. So after that, that also cannot be done. That also cannot be done. In the light of this Vinobai's restriction, suppose during the course of trial, the names of the accused, some new persons appear. Then Vinobai says it is only 319 which can be invoked. Right? 319 which can be invoked. Well and good. No dispute. No dispute over that. 319 can be invoked. Now the issue is, in our state there was a case where a woman was allegedly killed. Husband was prosecuted. Trial went on. The case was at the stage of 313. The so-called woman who was killed suddenly appeared in court. Now, if you apply the Vinobai doctrine, then you cannot order for further investigation. The judge cannot order for further investigation because the power is restricted. He cannot order for investigation. Now it is crystal clear that the woman is alive. Therefore, the man is entitled for discharge at that stage. Further proceedings are to be dropped. But this can be done under 232. He need not go to 235. Under 232, he will do. What will happen to the dead body which was found already? Does it not require further investigation? Who will do that? If Vinobai is applied, the judge cannot order for further investigation. Police also cannot make an application under 173(8) for further investigation. So to this extent, I find it very difficult to accept Vinobai.
Even the accused who are already arraigned, they may be innocent.
Yes.
Well, not only that, how can you say the police cannot file an application because new things are brought to the notice because the person
Vinobai has curtailed it up to the commencement of trial.
That's all. After that, 173(8) has got no application at all.
No application. That is.
No, the one.
Sir, one more thing, sir, Mr. Ramakrishnan, sir, before that, one more thing also, though incidentally I am saying this. Let us assume in a given case, 319 is invoked. Under 190, the magistrate so moto has not arraigned some person as accused. Under 193, as per Dharampal, session judge also has not done that. 2 failures. Now, after that, there was no further investigation ordered by the session judge until the framing of charges. Third fault on the part of the judge. Now, thereafter, trial commences, evidence is recorded. Based on that, 319 is invoked. Right? After 319 is invoked, my friend Mr. Prem will very emphatically say that the trial is to commence afresh. I agree with him fully because the evidence recorded in the absence of an accused cannot be used against him. There is no evidence as far as he is concerned.
273. 273 is the answer.
Yes. Now he is added as accused. Whatever the record already is no evidence. He is tried jointly with the others now, as per 319. Therefore, the evidence already recorded will vanish away. So, fresh evidence. That's what I was telling. That 150 witnesses are examined. There are 25 accused. 150 witnesses already finished. At that stage, 319 is invoked, 26 accused is added. As far as I am concerned, no witness has said anything so far. There is no more witness to say anything about me at all. Now, because you are adding some other person as an accused, which I do not want, without my consent, you put me on trial along with you, you force me to face the trial along with me, much against my wishes. You make a joint trial. You summon all the 150 witnesses. You make me to undergo the ordeal of trial again afresh to examine all the 150 witnesses. As Justice Ramkumar pointed out,
invitation for perjury.
it may lead to perjury also. So this is only an incidental issue which I am placing before our friends. So these are my comments about these two provisions. But though the issue which we today debate appears to be a very simple one, it's not as simple as we thought. It has got its own ramifications. Therefore, I invite the other friends to make their comment. Thank you so much.
Thank you, Justice Nagamurthy, sir. May I request Justice Ramashan, sir?
See, the practical situation will have to be gone into by, according to me, in one of the cases, I think in Justice Hema, after considering all those aspects and found that the accused arrayed were not the accused persons and acquitted all those them, thereafter ordered further investigation in one criminal appeal. It was reported also, I think, Ramkumar able to identify that case. There he said when the failure of justice has happened, suppose in a case where.
But it may not be under 201 or 156.3. 226 power is always there for the High Court. 226, Article 226 is there.
No, when a criminal appeal is filed, where the question of 226 arises?
Why? Pepsi Foods, 1998 Supreme Court is the answer.
No, that you have invoked, that is a different thing. That 142.
Court can invoke. No, 142. Not 142.
No, I don't see. See, this is a case where, suppose the Justice Nagamurthy was said, in a case where during evidence, the person who is said to have died, because on the basis of what identification was found that this person died was so and so and so and so. But the real person, the person who was alleged to have committed the murder, come and say that I am still alive.
Come alive. Yes, come alive.
Come alive. I can say. Now, what is the courts available to meet the ends of justice is the question. The court cannot say that hands are tied. Either you can close this case and direct them to conduct further fresh investigation. Can it not be possible?
Court said so.
Constitutional courts can order re-investigation, de novo investigation, but not the session judge or the magistrate.
Correct.
No, will it not be suppose will it not be available for the police to approach the government to say this is a situation, so permit us to conduct a re-investigation?
Government can order. JAC Saldana's case.
So there are at least you can postpone the hearing of the case, direct the police to approach the appropriate authority, get proper this thing, so that on that basis either this can be closed or it can be kept in abeyance. After the further evidence, this is. I think that when we go by the decisions alone, there is a possibility of failure of justice in criminal. The dispensation of criminal justice may come.
That criminal.
With the existing these things, you will have to go
without violating the law only, the section, the statute law only, criminal court can.
No, when the statute law also says where it is stated that you can, where it is just like only the V Ramkumar case only, what do you call that? Vinubai's case alone says that after the charge is framed or trial is inquired is started, you cannot do further investigation.
Sir, which session judge or magistrate will be emboldened to say, no, I will pass such an order for further investigation? Who will
I think in Kerala, in that Urtikole case and Thiruvananthapuram, the inquiry, during the course of the inquiry, it was found that there are further persons to be done, further investigation ordered during the course of trial. And that was challenged before the High Court, and the High Court confirmed it appears. And thereafter, new accused
that is under Article 226. Investigation, further. Investigation.
No.
It was not further investigation. It was investigation was entrusted to another agency.
No, that is during the course it was found that we will have to entrust to somebody else. But in what was happened in the trial court was that further investigation was ordered. When it was challenged in the High Court, it appears that instead of entrusting the same thing to the police officers, there is a possibility of further thing. It was entrusted to CBI, it appears. No, the trial court ordered only, the advocate court was ordered only further investigation there. I don't remember whether the public prosecutor has filed an application for that purpose or this court suo moto on the basis of the already, because all witnesses were become started hostile because I did not say.
Brother Ramakrishnan, you please comment. Please make your comment on the other issue also. That is whether the police doing investigation of 201 can summon anybody, can examine anybody, can record statement of anybody.
No, it cannot be treated to be an investigation under chapter 12 as such.
Correct.
But for the purpose of collection and placing before the court, something is required. Without that, how can the court come to the conclusion that the police has conducted some inquiry and some materials were placed? May not be, it will be helpful for the purpose of 161 or something like that.
No, this is not inquiry. Sorry, this is not inquiry, this is investigation. Pakka investigation. Investigation means collection of evidence. My friend V Ramkumar was saying.
No, not that. Even assuming that investigation was conducted. No, not sir. What I'm saying is, even assuming that the police is directed to convince against file a report.
No, what I am saying is, V Ramkumar was telling us that the restriction to get the signature of the deponent in the 161 statement, the statement of the witness under section 161.
That may not be available.
Is barred. Now, when he does investigate at 202, he can get he is free to get the signature. So my view is, when he cannot summon anybody, when he cannot examine anybody, how can he get the signature as well? See, suppose tomorrow I am summoned by the policeman. What I will do? You got no power to summon me. Second, see, I am expected to make a true statement, which is under chapter 12. Here there is no provision. I won't make any statement. Can you compel me to make a statement first of all?
Then what about the private person? He is also asked to investigate.
Yes.
But he is given the power of an officer in charge of a police station.
Police station only. So police officer can collect evidences, but can he compel somebody to make a statement? Can he record a statement? Can he obtain the signature? These are all my own doubts you have to clarify.
Signature, etc. I don't think that any incriminating circumstances or something is likely to come saying something about these things. I don't think this will be possible unless some other procedure is provided for, just like in Forest Act, something we can obtain a signature also. I don't think it's
so possible. Otherwise you can very well say that the procedure to be followed is the same procedure as prescribed in section RT in chapter 12. You can very well say.
That is what 202.3 says. 202.3 says, if an investigation under subsection 1 is made by a person not being a police officer, he shall have for that investigation all the powers conferred by this code on an officer in charge of a police station, except the power to arrest.
Very good. This is in respect of others. In respect of a police officer, if we are to interpret this subsection 3 to say that only powers means including the powers under chapter 12, this restriction need not be there. You can very well say that though the source of power is from chapter 15, procedure to be followed and all the regulatory measures are to be done only under chapter 12.
Yes.
You can say. So this subsection 3 is to be interpreted in such a way that is harmoniously to say yes, though source of power is different, the procedure for investigation, collection of evidence, recording of statement are all as per chapter 12. If you say that, then signature cannot be obtained. Statement cannot be used for corroboration. It is not evidence at all. It can be used only for contradiction. All these things will come.
162 may not apply.
No, if you are going to say by interpreting subsection 3, that all the powers, all the procedure under 160 under chapter
for collection of
evidence is to be used, then the 162 will also apply. 162 cannot be separated from 161.
Sir, take a case where a non-police officer is invested with the power of an officer in charge of a police station under a special statute like Customs Act or some other statute. Or even under the NDPS Act, Narcotic Control Bureau officers, they are given the powers of an officer in charge of a police station for conducting investigation. But they can't file a final report, police report.
They can only file a complaint.
No, they cannot file a final report, but the statement recorded by them, take for example, PMLA Act.
Not hit by 162.
they can record the statement. There is a specific provision given that they can record it. Even in NDPS Act, I think that it is section 52 or 53.
Yeah, 52.
Yes, it specifically empowers them to record statement. That statement is made admissible also.
Yes.
It is admissible. Therefore, these restrictions 161 or 162 are not applicable to them. Special provision is made. But so far as CrPC is concerned, there is no such a special provision in respect to chapter 15. That's what I'm trying to highlight.
No, not only that, suppose a report has been filed, it will not be treated as a 173 report.
We can't invite the views of other
Yes.
Friends. Shyam?
I think there is connectivity problem.
No, there is slight connectivity, but that's okay. So, sir, justice has to be done. There is no doubt. Whether justice can be done otherwise than through the enacted law would be the larger question. So, I request Prem to get on with the discussion so that we can open up for Vikas and Jagannath Rao. They have put their hands up. Your short comments, and then we'll go to them, Prem.
We are having Professor Raghuram.
Yes, I saw.
This is quite an interesting talk, and I have a genuine doubt, because this is where another interesting question can come up. We all know.
There is echo. There is echo, please.
Now, am I audible now?
Reduce your volume. Please kindly reduce.
Is there any other microphone in operation?
Now, maybe my phone was there. Now is it okay?
No, all right. Now, all right.
Okay. Here, we know that a magistrate, while he is ordering an investigation under 156(3), he cannot order a CBI investigation because it is hit by that 156(1) itself is very clear. Now, see the words in 2021. 2021 says the words are, it directs investigation either by the police or such other person as a magistrate thinks fit for deciding whether he can proceed or whether there are sufficient grounds. Now, my question would be, under section 201 CrPC, can the magistrate order for investigation by CBI?
He can. He can.
But not for filing a final report, only to assist him.
Only to assist, but they can file a report, may not be under 173.
Right, he can, because such direction can be issued not only to the police, to such other person as the magistrate deems fit, as you rightly pointed out. CBI is not a police, but still they can be directed to investigate. For a limited purpose of 202(1) alone.
Yes. So supposing Mr. Premraj is appointed for conducting an investigation, how will you assist the magistrate? How will you help the magistrate?
Unless the power for collection of evidence is given, known as provided under the CrPC.
202(3), subsection 3 gives that power. Officer in charge of a police station. Power of an officer in charge of a police station. Of course, we may have to resort to chapter 12 for collection of evidence. But I don't think 162 bar will be applicable.
No, not that. If that be the case, what will be the evidentiary value of that evidence collected, placed before the magistrate? How far it can be treated by him as an evidence?
I don't think it will be used.
Then what will be the purpose? What extent that can be used? That report can be used
only for issuing process or dismissing the complaint. Only for that purpose.
Probably that collection of evidence can be used by the complainant for the purpose of arraying them as witnesses and examine them before the court.
Maybe.
Probably contradiction may not be possible. But those witnesses questioned by during that investigation can be filed as a witness list, and they can examine. They can be examined.
Because
what about preliminary inquiry? The police officer takes statements of so many persons. Are they being summoned in court, or even if they are summoned in court, are their statements taken during preliminary examination? Preliminary inquiry.
What
is it being used?
What I am saying
is not investigation.
Assuming that for the purpose of taking cognizance, that report is taken by the magistrate.
Yes.
Suppose only for that limited purpose it has been taken. How because the complainant has not produced any witness list, complainant had not given any evidence before the court or material before the court. All those things have been relied on by the magistrate for the purpose of issuing processes that report. If that be the case, how the further proceedings can be proceeded in a on the basis of private complaint is the question.
But if any of those witnesses are examined during trial, subsequent trial, then their previous statement recorded by the police officer or whoever it be can be made use of by the defense.
Definitely. Definitely.
So they will have to be summoned again.
Yes.
Again, chief examination, etc. will be done because you cannot.
And the defense can confront them with their previous statements recorded by the police officer during the investigation under 202(1).
No, suppose if it is not 160, see, if it is examined in court, it is all right. But before taking
examined in court.
Before taking cognizance.
Take cognizance is already over. 200 stage is over. 202 inquiry.
No, once that is over, then the other stage will be evidence, taking evidence under section 242 or something like that. It is a warrant trial or something like that. For the purpose of framing charges only. Only for the purpose of framing charges in a private complaint.
And they constitute evidence.
There is that will constitute because after framing charges, you will be getting an opportunity to cross-examine on that basis.
Correct.
Even the constitutional bench held that 200 examination, the statement of the witnesses during 200 examination, though they are strictly not evidence because it was not recorded behind the back of the accused, they can be used during trial for the purpose of corroboration.
Yes.
But I don't know why it is confined to corroboration only. Why not contradiction? Supreme Court did not say so.
No, is it not necessary when you are summoning a witness, issuing a process after taking that evidence? That evidence, along with this thing, are you not expected to send it to the accused also to know that on the basis of that only they have taken? Just like 173.
Sir, we may allow Mr. Prem to complete his comments, then we can comprehensively.
Okay.
Also, I will come in later. Let the other part.
Over. Okay.
He ignited the light.
There are others, so that
He had set the fire to flame will out.
Answer comprehensively everything.
Yeah, with your permission, sir, can I request Raghuraman, sir?
Thank you very much, sir. My opinion on investigation by police under section 202, I agree with Nagamuthu, sir, because they have got the powers under chapter 12, because once it is an investigation, even though it is ordered by the magistrate, naturally they will get all the powers except to arrest the person. So suppose if they ask me to give witness statements and they compel me to sign the statements, I can refuse because I am having a witness is also having some rights. So at least one or two rights are there for witnesses also. So as a witness, I know about section 162. I am having a knowledge about 162. I can say I will not sign it. I will come to the court when I am asked to come there, and I will tell the same thing, whatever it is. But I don't want to sign. So that is why I think witnesses is also should be recognized as having some rights which they can exercise within the parameters of the law. I think that is my observation, which I am thinking I am sharing with you. And another observation is after that is trial commences, I also agree with Nagamuthu. Why can't the court can order for a further investigation to go into the bottom of the case as it happened in that fine example he has given? Because in one or two cases which I have come across in UK, in bigamous marriages, that has come because after suddenly that person comes back. In one case, Queen's Bench Division, 13 judges have sat. That is a sensational case, and she married, and suddenly this person has come back. Then the question was, they said that the second marriage cannot be reopened and re-examined. And like that, they have given some judgments. That is also there, because ultimately the court has to go to the bottom and do complete justice without about technical problems. No doubt, there are some provisions which are strictly to be enforced wherever it is. But I feel that the committee which is appointed, that latest committee is appointed on criminal amendments. Some committee is appointed, the National Laws University Delhi. That committee is inviting some amendments or some public opinion. So that is also one thing which we have to see. All these loopholes or some missing links must be plugged, so that the police must have efficient investigation to correct the proper relevant evidence, and also the judges must be given all the help which they must get from the police officers and others. That is my opinion. So I just wanted to talk to all the audience for a few minutes. Thank you very much for your kind permission. I am very, very happy to be a part of this session. Thank you, sir. Thank you.
Thank you very much, sir. It is indeed our privilege, sir. Thank you. Vikas, you have put your hands up. Would you please unmute and put your comments?
Hello. Good
Hello.
evening, sir. A complaint was filed under section 200 CrPC, and after that, magistrate referred that under 2.21 to police for inquiry, and police called both accused and complainant in that inquiry, is so-called inquiry, and after that they take statement of some another case, and so they basically filed that report against the complainant, de facto complainant. But after that, the magistrate proceeded under take statement of complainant and her witnesses. Is it legal or something else? Because earlier, before referring complaint under 2.21, magistrate first take a statement of complainant on oath and her witness also. And after that, he referred that under 2.21 CrPC to police. And again, he retracted and he takes statement of witness of all complainant witness. Is this legal process, I mean to say?
In fact, that is precisely precisely the question in Biju Purushottam versus State of Kerala. There also, after ordering investigation under 2.21 CrPC, where the question was whether magistrate could still conduct the inquiry under 2.2. It was held that he could conduct.
Yes.
Okay, thank you so much, sir.
Thank you, because we have Jagannath Rao here. Jagannath Rao, sir, please, can you unmute?
Good evening, sir. Justice Ramkumar and Shyam, sir, thank you. This is a subject. Yes, exactly. I was coming to that because the conundrum it raises is what we are facing right now. And I face this every day in court. Sir, under 202, as Nagamuthu sir said, he cannot record a statement, he cannot take signatures, nothing. Now, the 2017 Ramesh Shopti judgment of the Calcutta High Court says the police officer is the delegate of the magistrate. So if the magistrate does not have the powers to summon the accused or record the statement, how does the police officer get it? So that question is answered. The second one is 2021 and 2023. So 1 is the police officer and 3 is the same powers as the police officer. So now can 3, the powers of the person under subsection 3 override the powers of the police officer in subsection 1? If that means you're giving a person who's not a police officer more powers than that of a police officer.
So, you find it in several statutes like Customs Act, etc. Non-police officers invested with the power of an officer in charge of a police station.
Yes, sir. But again, sir, then they come back to file a complaint, but they cannot file an investigating report, sir. That is the conundrum. That's what I'm saying. Like, and I have this every day. And now, if you go by the latest judgment of the Honorable Supreme Court of 15th August in XYZ versus State of Bihar, the Justice Chandrachud has gone on to say that the word may in 156.3 is not a choice to the magistrate, but it directs him to apply a judicial mind to establish whether cognizable offences are revealed or no, and to direct the police investigation. So it doesn't leave much of a choice. And sir, now another conundrum is, assuming the police officer has recorded statements, accused statements, everything is taken on record. Now Prakash Chandradev's judgment, Constitution bench says, irrespective of whatever the police report is, the magistrate is bound to issue process. A lot can be said on both sides, so don't go into it. So you issue process. So
provided there is incriminating evidence, is it not?
Yes, Your Honor. I mean, yes, sir. There is, like I'll give you a simple example, sir. There is a complaint made by me. The accused have come and said, yes, we have not done what is the statutory requirement of the law, and it's a loss of 300 crores. The police officer still says that no, but for 2 years, if they've done this, not followed the statutory provision, but after 2 years, they paid their penalty and deposited that money. That means there is no fraud involved. So it is like saying somebody's robbed your house, he's come back, he's given you the property. So that means that no case exists. So you see, the thing is, the police officers also arrogate powers themselves much beyond the scope, sir. And under 202 now, like, you know, which is in challenge now, right by me, the police officer has, a judge has agreed that the police officer has exonerated the accused. Sir, if the police officer can exonerate the accused under 202, then the question of having all the other procedures is not required, na, sir.
Sorry for interference.
Yes, sir.
That is what we are also saying. You can very well say that all the powers of the police officers, which are regulatory as per chapter 12, can be made applicable here.
Yes.
Simply, but the Supreme Court only says that chapter 12 is not applicable. That's a
Correct.
problem.
Yes, sir. That's where I'm coming to, Nagamothu, sir. So everywhere, like, you know, every time I have to keep arguing the same thing, Your Honor. And second thing is, normally when the magistrates convert a 156(3) application into 200 and send it to the police, now the police who did not file the FIR in the first instance are going to sit on their own cause. So that becomes another conundrum. So you think a police officer who did not register the FIR in the first instance in a 202 report is going to say that no, there was cognizable offences and we erred in not filing the FIR. It defeats, I mean, common sense, it defeats logic as well. And this is what I face every day.
There has to be a way out.
Correct. Sir.
We have got no difficulty in understanding this basic principle.
Correct, sir. But
has given a judgment contrary to that.
Unless it is changed, how can it be done is the question.
Yeah, that is a problem. See,
yes, sir. This thing raises so many conundrums, Nagamothu, sir, that you're a professional lawyer. You
exactly.
Can argue, but
brother Nagamothu,
you have a face value in court. I don't have a face value in court. I'm detested in court.
No, you are right, sir. You are.
As a whistleblower, I'm detested in court, sir.
We have you there in the Supreme Court only for that, Mr. Nagamothu.
You and Basant alone can do something there.
So actually, then 202 is an exercise, a futile exercise. It is wasting, and police officers, sir, are sitting on a 202 application for 2 years, 5 years. So the whole purpose of the filing a complaint is defeated, because in that 5 years, a lot of things change. Anyway, thank you, sir. That was my conundrum. Thanks, Shyam, sir. Thanks, Ramkumar, sir. Once again, like I said, I love this platform. So that's how it is.
Rao, sir, your change, I mean, the name, your full name has been written, so that creates a
No, that, sir, unfortunately, no.
With your sound only, I think that name.
Yeah, otherwise we would have missed out on you.
We recognize you through your sound.
There's some problem with my software, sir. It is switching my names. So that's why even my camera is not coming on, sir. I'm having a problem with that. I'm sorry, sir. Yeah.
Thank you, KVJ Rao, sir. Shoaib Hussain, please.
Yes, sir. Good evening, sir. Sir, nothing much about it to say. There is really a conundrum, and after having gone through Ramkumar sir's lessons, I am still under confusion, and I wish to share my article with all of you wonderful participants, sir. So until then, sir, I reserve my comments on this thing, sir.
Who will resolve the conundrum is the question.
Correct. Exactly, sir.
Who will bell the cat? Fine. if any further comments or any inputs are there, please feel free. So that if you can just put your hand icon, I can unmute you so that let us have some more constructive inputs before we go for the final comments from Ramkumar sir, Nagamuthu sir, Ramkumar sir, and Prem. Okay, so that be it. If any further comments, Nagamuthu sir, anything more to be added, sir?
Or it would be in.
Sir, you let unmute, sir.
Justice Ramkumar may
I'll come.
make his final comments.
Sorry.
Yes, you may make your final comments.
Final comment. I'm not the Supreme Court or the Privy Court. I will add on to that, to whatever has been said. Now, it is a real problem. The Vinubai has restricted it to the stage up to commencement of trial. But I feel that Hemant Dashmana, where the Supreme Court said that the power of the police under 173(8) CrPC can be triggered into motion by the court for doing justice. Therefore, now nobody disputes that the police has got the power to conduct further investigation at any stage, even after commencement of trial. Police has got the power under 173(8). Yes. So Vinubai has restricted that power only to the court exercising that power. No, I will say that if the power of the police is there till the end of trial, why not the court also, which is triggering into motion that power, exercise that power? Even after the framing of charge, even after the commencement of trial.
So, Mr. Shyam, my final comments would be,
sure,
the issues which we have debated today is not very simple.
Exactly.
Actually, to be on the practical side, it creates a lot of problems. There is no uniform procedure being followed.
Not Mr. Nagamuthu sir, what I am saying is, when such issues are coming before the court in some other matter, can it not be projected that this is not providing the correct thing? Because now Supreme Court is trying to revisit all the issues again, going by constitutional bench or three judges bench, etc., etc. Can it not be possible that certain issues which are causing practical difficulties on account of
because of their workload, they simply say that we are not prepared to do this academic exercise. So
it is not academic exercise.
It is not practical. Legal.
No, sir.
This 319 issue I raised in one case. They said, no, you keep this, we leave it open, you can raise it in an appropriate case. I said that this is the appropriate case. They said, no, we are not prepared to, we are petition on other grounds without touching upon this ground. This is left to open, you can raise it in an appropriate.
Whether you got an acquittal order or a conviction confirmed.
Only SLP.
So that way,
SLP.
That way, then everybody.
SLP, if it is admitted, a notice issued, always this question can be heard during the later stage also.
SLP was dismissed on other grounds.
Oh.
They did not go into this. I said that you please dismiss it, no problem, but to settle this is creating a lot of problems. The answer was that we cannot do the academic exercise given the workload for us. So you raise it in appropriate case.
Not that. Can it be said to be an academic thing for the purpose of knowing things when there are issues arises which creates problem for conducting investigation, or the restriction the power of the court also doing certain justice? Will it not amount to miscarriage of justice?
That is a view of the judges of the Supreme Court.
And I still do not know whether the statements of witnesses, persons recorded by the police officer during the investigation under 202(1), whether they are marked in the case, and whether they are made available to the defense for the purpose of confronting the witnesses. I don't know whether they are actually done.
To my knowledge, there is no judgment on these aspects.
No judgment. Likewise, the preliminary inquiry. During preliminary inquiry, the investigating officer or the police officer conducts a preliminary inquiry, question so many persons and record their statements. 64 Supreme Court, that Bhagwan Singh, or which is, I don't remember the name. They said the concurring judgment of Matolkar said that they need not be produced before court.
No, the VK Sasikala's judgment, that in Jayalalitha case, says that you can make use of any document collected during investigation, whether it is relied on under 207 or 208.
But this is not investigation, preliminary inquiry.
Forming part of the records. That's what they say.
So the courts don't want to interfere because then Justice Ramkumar will get another topic as judge-made laws. So
Thank you, sir. Thank you, sir.
and they say that is the territory of the legislator and we don't want to interfere into that. So that's
Thank you.
Vacuum. There's a vacuum left by the legislature.
Yes,
Court
sir.
is filling the vacuum.
Thank you, friends. I may take leave from you now.
Sir, we
Thank
are
you, sir.
coming
Thank
to
you for
the
your
end of the session, and Supreme Court is supreme, not because it's infallible, but because it's final. That's so. Prem, your final. Let us have the concluding remarks and let us wind up the session today.
Well, I would just say, because as Justice Ramakrishna has put it, Pepsi Foods, that's a 1998 decision, AR 1998 Supreme Court 128, where the Supreme Court has held that the magistrate, he has to apply his mind to the very facts of the case, as well as to the applicable law. And he has to examine the entire nature of allegations which are made in the complaint. Of course, it's not a full-fledged or fully dressed trial, I know that. But he has to appreciate the evidence, and then he has to take the call, like forming an opinion, whether a prima facie offense is made out for issuance of summons. Now, this is a settled position of law. And we all know, by its very nomenclature, CrPC, that is the compendium of law which regulates the law regarding criminal procedure. And the entire provisions of this procedural law, as we know, it is required to be interpreted, keeping in mind the well-recognized rule of construction that procedural prescription, it is meant to advance substantial justice. We should not pick the words from here and there and try to interpret in such a way that you are not advancing justice to the party concerned. Of course, equally to the victim as well as the accused, because earlier there was no victim in the CrPC, as we know. Now, please see. As we know that section 202, the scope is very, very limited, because Justice Ramkumar himself has cited Mohinder Singh's rule. That details out, it's having a very limited scope of a very limited nature, merely to find out and to form an opinion whether a prima facie case is made out to issue process. And secondly, to prevent the issue of process in a wholly false or vexatious or merely intended to harass a particular person who is arraigned as an accused. So evidence is not to be meticulously appreciated. It's only for the limited purpose of finding out whether or not you are having a sufficient ground to proceed against the accused who is arraigned. And here, of course, I would partly agree with Justice Nagamuthu saying that, of course, you don't have the power under Chapter 12. But at the same time, you cannot simply brush aside by saying that you don't have the power under Chapter 12. So you cannot record the statements. Because by giving a power for investigation, kindly see the word used is investigate. The legislature very consciously held that put the words, either the magistrate may inquire into or direct an investigation either by the police or by such other person. Now, please see, the police is given a power to investigate. That means all the other powers, it should be deemed to have been given. Otherwise, you cannot take that investigation to a logical end. This is my humble view. I'm subject to correction. Thank you all. Thank you for your patient listening. And it was absolutely good learning, because even though it was a very, very minuscule topic, we had great deliberations, and I think it cannot be stopped maybe within an hour or something like that. We may need more deliberations on this particular topic, because there is much more to learn. That's what I think.
Thank you, Prem.
Thank you.
As we come to the end of the 276th session, let us thank Ramkumar sir for introducing and presenting the topic, and all of you for proactively participating constructively, especially Justice Nagamuthu sir, Justice Ramushan sir, Raghuraman sir, and all of you. It was, like Prem said, a wonderful experience, a Saturday evening well spent, and till we meet again next Saturday. Do take care.
It is.
Stay safe. Thank you.
Thank you, sir. Thank you.
Thank you.
It is an excellent speech by Ramkumar and Nagamuthu, sir. Really. See, I'll be happy to join every session to be abreast of latest law. That is why. Thank you, sir. Thank you.
You are welcome, sir.
Thank you, sir.
Any day, anytime.
It is a great lecture, and your fingertips, you are having all the case laws. You are really a top criminal lawyer.
But our Premraj is a ready reckoner. I have no comparison. I have no comparison with it.
So Premraj is, because you are telling Premraj's name, I will also think Premraj is also having fingertips, both of you. It is really a great experience, sir. Thank you very much.
Thank you. Thank you.